5 seconds. During this period, except on Sundays and holidays, appeals, petitions, etc., will be received at the court at Chandigarh from such persons as may choose to present them. Emphasis ours the above notification unambiguously provides that during the summer vacations, that is period between June 1st to June 30, 1996, both days inclusive which the High Court of Punjab and Haryana at Chandigarh would remain closed for civil business, it would be open for hearing of election petitions or any other matter arising out of the Representation of the People Act. The learned election judge of title High Court was under the circumstances justified in holding that benefit of Section 10 of the General Clauses Act was not available to the election petitioner to save the period of limitation, as undisputedly the election petition had been filed on reopening day of the High Court after summer vacations, but after the expiry of the period of 45 days prescribed under Section 81(1) of TLI Act, which period had expired during the period of summer vacations. In view of the clear language of the notification, there was no impediment in the way of the appellant to present the election petition during the summer vacations. The judgments in Hari Shankar Tripathi versus Shiv Harsh and others and Simhadri Satya Narayana Rao versus M. Buddha Prasad and others supra relied upon by learned counsel for the appellant are clearly distinguishable. In the notifications issued in those cases by the High Court of Judicature at Allahabad and the Andhra Pradesh High Court respectively, the entire period of summer vacation was declared as closed holidays in the case of the High Court of Allahabad, and for the entire period of Sankranti vacation, the Andhra Pradesh High Court was also to remain closed. Unlike the notification of Punjab and Haryana High Court dated 27/11/1995, in none of the notifications setting the vacation in the High Court of Judicature at Allahabad and Tilai Andhra Pradesh High Court was an exception made with respect to the hearing of election petitions or any earlier matter arising out of the Representation of the People Act. Section 10 of the General Clauses Act was in Tilayo's cases clearly attracted to save the period of limitation by filing an election petition on the first reopening day of the High Court since the prescribed period of limitation had expired during the closed holidays or Sankranti vacations. It was in Till's fact situation that the cases of Harisankar Tripathi and Simhadri Safia Narayana Rao were decided. Those judgments therefore cannot advance the case of the appellant. On the other hand, the judgment of this court in Satbir versus Piri M.T. Parsani Devi and others Supra, which considered a notification issued by Punjab and Haryana High Court on an earlier occasion in identical terms as the notification dated 27/11/1995 applies with all force to the facts and circumstances of the present case. In Sadbir case Supra, the benefit of Section 10 of the General Clauses Act was denied to the election petitioner, and the election petition not filed within the period of 40 live days which expired during the summer vacations but filed on the reopening day of the High Court after the summer vacations was held as barred by time because of the action contained in the notification regarding the hearing of election petitions etc. during the period of summer vacations.